We'll now take up the case number 19-1819, Pinellas County versus Joyner.
May it please the court. I'm Christy Pemberton on behalf of Pinellas County, a political subdivision of the state of Florida. With me today is my co-counsel, Don Kroll, who will be handling rebuttal, for which we would like to reserve 8 minutes. For over 100 years, this court has held to the principle that counties partake in the state's sovereign immunity. Immunity from ad valorem taxation is just one facet of that immunity. This court has recognized that sovereign immunity is derived from the separation of powers. The legislature has the power to waive sovereign immunity by general law. Waivers must be clear, express, unequivocal, and this court has previously declined to infer a waiver. The Second District Court of Appeals did not find that the legislature has waived immunity where a county such as Pinellas owns property in another Florida county, such as Pasco. And in fact, there is no such waiver.
Maybe I've got waiver on the brain today, is it your position that legislation is the sole, that it is exclusively the province of the legislature to waive sovereign immunity, and that no amount of executive action or inaction can ever constitute waiver of sovereign immunity?
That is my understanding of the current case law, yes. And I would assert with regards to ownership of property from one county owning property in another county, the legislature has granted to counties the ability to use the delegated sovereign power of eminent domain to take property in another county. So they know that the county could own property in another county, and yet with that, they did not add a waiver of sovereign immunity from ad valorem taxation.
Can you give me your best source for the concept that sovereign immunity extends beyond your boundaries?
The best source.
Florida owns property in Georgia. Native American reservation owns property outside of its boundaries. What is your best kind of historical, any reference for how that sovereign immunity extends?
That specific issue has not been addressed by a Florida court, but if you go back to Kagan in the 1900s, that said that counties derive their immunity from the state, and then you look at your history of ad valorem tax law from Park and Shop, where a county had leased property for a private use, and the government said, or the court said, nope, still immune, to Dickinson, where the city of Tallahassee was attempting to impose a fee on the state and the county and the school board, and the court said in 1975 in Dickinson that the state's immunity, and it was using state broadly to talk about the county, the school board, and the state, that the immunity from taxation was so well established that little elaboration was needed. When you look at the Florida Constitution,
but that's never been in a context where you have county versus county, and one county owning property in another county. It's just never come up.
It has never been, this issue has never been litigated before.
This has never really been a focus, where you have these two subsidiary entities that have an element of sovereignty where they're in conflict. That's just not been addressed, has it?
No, it has not, but...
That's why we're here today.
That is why we're here today. But the court has been very clear that the counties derive...
We haven't been clear on that point because we haven't had to address it.
But you've been very clear that the counties derive their sovereignty from the state.
Yeah, all of them do.
All of them do. But it's the state's sovereignty.
But the state wouldn't have any sovereignty in Georgia, right? I mean, if we bought land in Georgia, we would pay taxes as a state.
There is case law that does support that. And if Pinellas County owned land in Georgia, we would pay taxes on that as well.
Sovereign immunity is not something that you carry with you no matter where you are. I mean, a foreign country buys property here, they're going to pay taxes. So why would a county going completely outside its bounds of jurisdiction be able to claim it simply because it's derived from the state? Let me divide that into several issues if you allow me to do so.
One thing, and it's not addressed, I don't believe, in either brief, the court in the certified question uses jurisdiction, but that's a little bit problematic. You know, as a county, we have certain jurisdictions countywide, but in municipalities, there are things which the county does not have jurisdiction over. So let's put it as geographic boundaries, which I think is pretty much how we have all talked about it. When you're looking at the case law that is cited by the property appraiser, we're talking about states that came together to form the United States, whereas the state of Florida was carved into counties. So they are different in that respect. Also, when you look at Florida Statute 768-28, and if you'll excuse me for a minute. Thank you. The legislative waiver of sovereign immunity, that is a limited waiver of sovereign immunity for the state and the counties, and it's a grant of sovereign immunity for municipalities. But when you look at that, the analysis there for an employee, for example, is was the employee acting within the course and scope of their employment at the time of the tort? And if they were, then the sovereign, the county, would be liable. That doesn't have any geographic boundaries. So until the ruling of the court below and their reasoning that said that Pinellas County can only have sovereign immunity where it's sovereign, there was no question that when I got in my car and drove up US 19 to come here, I had sovereign immunity. Now, looking at the reasoning of the court and the drawing of the lower court and the drawing of boundaries, that calls into question that body of case law as addressed by the Florida Association of County Attorneys in their amicus brief as well as in our brief. So if you look at tort immunity, there's not a lot of decisions on that. The Fourth DCA in Ryan v. Roy found that a law enforcement officer who was outside of his municipality when he was involved in an accidental shooting, it was an intentional shooting that accidentally injured a person, they only looked to whether he was in the course and scope of his employment. And they found that the employer could reasonably expect and allow him to leave his municipality, and that he was on a break, he was in the course and scope, and so sovereign immunity applied. Also, if you draw from case law on exemptions from ad valorem taxation, municipalities don't have the sovereign immunity, but they have exemptions. And this court previously found where the legislature had authorized, I believe it was the Orange County Utilities Commission, to cite a power plant both within Orange County and in a neighboring county, that the property that was located in the neighboring county, even though no electricity from that plant was provided to the neighboring county, was still had a tax exemption.
That's based on a specific statutory exemption, correct?
It is based on the exemptions for municipal purposes, and their authority to locate it there was statutory. And so that's one of the issues that we address. If you look at this through the lens that the Second DCA did, and you draw that line around Pinellas County, and you say any property that you have outside you're not immune for, that creates an absurd result between immunity and exemptions, whereas a municipality could have an exemption, but the county wouldn't be immune. And generally, with regard to sovereign immunity law, you know, the county is considered the state.
Is it your view that that property is subject to Pasco County's zoning laws?
Yes. We are not asserting that we have any sovereign jurisdiction there. We're not asserting that we have any sovereign power there, but because it is located within the state of Florida, we have the sovereign immunity of the state there, both from tort as we do statewide as well as from ad valorem taxation. That would be our position.
So obviously the court is going to try to do its best to make sense of these competing kind of background principles, but if we write something that is limited to the tax context and we distinguish the tort cases, are we essentially, regardless of which path the court takes, leaving this as something that the legislature could sort of fix one way, in either direction if they chose to address it legislatively, or is there one path that sort of takes it out of the hands of the legislature?
I haven't really thought through that question. I don't believe that anything that you would decide here today would take it out of the hands of the legislature, whether you rule on behalf of Pinellas County or you narrow your opinion to strictly ad valorem taxation. Perhaps if you find that we're not sovereignly immune, I guess that would be out of the hands of the legislature.
So there are these sort of cosmic first principles sort of floating around, but if we really just view this as kind of a tricky sort of policy thing that where there are, things on pointing in both directions, and we just need to set a default, limit it to the tax context, and then essentially the legislature can handle it however they want to.
I would urge you to set a default and find that Pinellas County retains its immunity throughout the entire state of Florida, and allow the legislature, should they deem there to be a problem that needs to be addressed, to address that problem. Pinellas County has owned this property for a long time. We bought it the year after Dickinson was decided. So you don't see a lot of these cases because there haven't been a lot of issues, and this court in the past has declined to wade into those policy decisions. Obviously, as you can tell from our brief and the intermingling between ad valorem immunity and tort immunity, it gets very tricky. And then when you look at the tax statutes and your decisions in regards to the tax statutes, my colleague likes to say you're pulling a thread on a sweater. And that's kind of where we're at. If you look at your decision in Cason, for example, in 2006, where you found that the state was not a taxpayer for purposes of the non-claim statute to challenge ad valorem taxation, you looked at the provision of Florida statutes that says that a certificate cannot be issued and a lien is not created on property that's owned by a governmental entity that becomes subject to taxation through a lease for non-governmental purposes. And you said in that decision that the legislature never contemplated that the state would be a taxpayer whose property could be lost through the non-payment of taxes. And yet, under the decision before you, that is where Pinellas County stands. We are a subdivision of the state. Our immunity is derived from the state.
It seems like you're trying to take on the complete power of the state, which you're not. I mean, I know of no authority, no case, no other kind of constitutional authority that would permit a county to assert their sovereign immunity beyond its own borders. Do you have one?
Aside from the cases in torts, no. But we're not asserting immunity. It's something we would argue that immunity is something that we are vested with. It's inherent in the fabric of who the county is because we were constitutionally created as a subdivision of the state. And should this the policy concerns be sufficient enough concerns, the legislature could craft a waiver of immunity to address this, just like they have in 768-28. And I see I'm at the end of my time. Unless there's any more questions, I will cede the podium. Thank you.
Thank you, Your Honors. May it please the Court. My name is Lauren Levy. With me today at council table is Sidney Rodkey, and we represent the current Pasco County Property Appraiser Mike Wells, Jr. This is, very admittedly, a unique case, and it arises in an area that's fairly unique to itself, and that is property tax. Property tax is all I do. It's a very small niche, and in many respects, it is an intellectually intriguing case. Whenever you have a case that you don't have anything directly on point, and you try to decide how do I put the pieces together to make the most sense of the constitutional boundaries that we have, I think it's always interesting and intriguing for the practitioner. I wanted to start with, council talked about the Cason case. That was simply a county attempting to tax the state. That is the parent-child immunity that we have and has been well established in the case law of this court. It's not the situation that we have here today.
Well, it seems though the Cason stands for something else, which is the sort of fairly unique power of the legislature to waive sovereign immunity. And I guess how do you answer the argument that that power under our cases resides exclusively in the legislature and that the legislature must act not for policy reasons, but constitutionally, it is only the legislature that can waive sovereign immunity, and there has been no such waiver here, right? There has been no affirmative statement by the legislature doing that.
Well, I think there's an argument under 196, 199 that they would have reached that issue. But, Your Honor, I think the first step is, does immunity exist beyond the county's boundaries? If that answer is yes, then it would be the legislature's prerogative to waive that immunity. Shy of that, which is the case we have here, we are dealing with a common law theory that's been expounded upon by this court through its decisions. And certainly this court would have the ability to say what its case law means and says and how it should be applied in a given factual scenario. So your original question that you asked, is this exclusively within the authority of the legislature? I would submit, no, Your Honor. This is a common law doctrine that the court has expounded on, and the court can say what the law is. If the court were to determine that Pinellas County is immune for property owned in Pasco County, then you would be looking at the legislative waiver, which when you look at the Second District Court of Appeals decision, you'll see they have a comment where they remand it back and they say, remand it back to do what we said to do in our opinion, and you may also look at any exemption issues. That reference was to the 196, 199 provisions. It says property owned by the counties, cities, et cetera, is exempt from ad valorem taxation if it is used for governmental, municipal, or public purposes, I think is where the district court was going there. But we don't think the immunity exists. When you look at sovereign immunity from tort and sovereign tax immunity, they may have the same origin story, but they're fundamentally different types of immunities, if you would. The sovereign immunity from tort recognizes that the king can do no wrong. The sovereign tax immunity is built upon the court's recognition that we've got to decide how tax issues should be resolved among competing political sovereign bodies. 1819, we had the McCulloch case out of the United States Supreme Court that says a state cannot tax the federal government. There was no language that said that. There was no congressional intent to prove that up, but the Supreme Court said that is the only way we can have a proper functioning and recognition of the respective powers of the state vis-a-vis the federal government. This court has tracked along that same line of reasoning in its Dickinson case, where it said the city, that is the child, cannot tax the parent, the state government. Likewise, it's recognized that the county may not tax itself, and likewise in Kaysen, the county cannot tax the state. And the court has recognized that these things are necessary for all the pieces of government to work together. They have to be inferred. And it's always troubled me in this case that we're trying to evaluate Pinellas County's claim to an immunity, which is inferred from the proper functioning of government, against Pasco County sovereign right to tax, which is an express right in the Florida Constitution. And so, kind of if in doubt, where would you go? Well, I think you would go to where we have the express right to tax is set forth in the Constitution versus an inferred right that puts together all the pieces of government. And I think you would defer to the express right. There would be no basis in this case to say that somehow Pinellas County should assume this mantle of the state and somehow vitiate the sovereign powers of Pasco County when they acquire property therein. There's really no basis for that. When you look at that old Amos versus Matthews case, which is at least 30 or 40 pages long. It's a very long case, and in the style of the court back in that era. But it was talking about, yes, counties are a political subdivision of the state, but they are in many respects autonomous from the state, and they have their own boundaries and they have their own powers. And I would want to point out, with particular regard to ad valorem tax, the difference between counties and the state is even more profound, because the state is not allowed or authorized to levy an ad valorem tax. That right is reserved to the counties. And the counties alone and the cities, the other taxing authorities, may levy this ad valorem tax, but the state may not levy the ad valorem tax. And so to me, that further separates this idea that somehow Pinellas County can say, I want to assume the mantle of the state. And it shows a little bit of the inconsistency in the argument, because they want to levy an ad valorem tax. They do levy an ad valorem tax in Pinellas County. If they were the state, they could not. So I think that would be an inconsistent conclusion. There's no concerns here with regard to the fiscal policy. There's no taking of money, as it was discussed in this court in the Dickinson case. The child is not trying to take tax dollars from the parents. It's not the McCullough situation. It's two co-equal, in all intents and purposes, siblings of the state. And what happens when one of those siblings decides it wants to go beyond its boundaries and to acquire property in another state, in another county? What, who must yield in that circumstance? And again, when you're going beyond your boundaries, I think when we have to put together the pieces, that you should yield to the county's right to tax. Because if we come up with any other solution, it's going to could lead to some fairly absurd results. And the district court talked about the buying of the hotel, because the idea is I'm immune from ad valorem taxation regardless of what I'm doing. I could buy Disney World and engage in that function, and I would be immune. And that would be a fairly absurd happening, but it would be there. But I think it would be far more likely that you would struggle with questions such as a county buys a significant body of property in another county to dispose of its garbage.
Let me get you to address the specific opinion below, and that's, I know you like the result and the reasoning. Is there any part of Judge Atkinson's opinion that causes you some concern, or do you agree with all of the reasoning there?
Your Honor, I agree with his reasoning. What causes me concern is when you look at the very old U.S. Supreme Court case between Georgia and Chattanooga. The U.S. Supreme Court there said when a state acquires property beyond its boundaries, it does so as any other private citizen. Okay? Judge Atkinson's opinion, when he remands it back and says we need to go back and we need to talk about an exemption now, that concerns me. Because I do think once the county acquires property outside of its boundaries, the closest case law we have is that it does so as any other private person. I mean, that thread, if you would, runs through the Indian country cases. It runs through the foreign nation type of cases, that if that happens, you are conducting yourself as any other private citizen. And so I would think if we were to find no immunity exists, the conclusion would be that the property would be taxable, and we would not be going back to now to try to decide whether some exemption exists.
Was there an exemption claim by the?
Not in this record, Your Honor. To the extent that we have the record, the argument has always been we're immune and we stop there. So
the remand for exemption purposes was just the second DCA created that? It wasn't something that was litigated?
Your Honor, frankly, it was discussed in oral argument, and I think where the District Court of Appeal was going there was somewhat of a, I don't want to pre-decide an issue that's not really before me. They talk about, there's arguments about exemption based upon use, but the record's not developed, so we're not going to go there, and we're going to kind of leave that issue, and maybe it would be best left for another day to talk about would an exemption be applicable. You know, we would suggest the record would show no. Pinellas County owns 12,000 plus acres, and like many other large landowners in Florida, a property like this, they're using it for agricultural pursuits. They've got cattle, they've got hay, they've got pine straw, they've got a timber operation, they may have some row crops out there. We're not quite so clear about that. And there are thousands of acres of swamp, or what I would call Florida, the land that holds Florida together. And we have many, many large ranches in Florida that use their property just like that. And I would submit, well, that's not in any way a governmental use of property. That's like any other private person. But if you're asking me, is there any concerns that I have with the Second District Court of Appeals decision, that would be my concern. I do believe that
Could I ask you this?
Yes, sir.
On the sovereign immunity from tort, do you have any concern? Because your client would get the benefit of sovereign immunity from tort. One of the employees happens to be driving to a conference somewhere. That would be something that your client would be concerned about, having that extraterritorial sovereign immunity from tort. Are you concerned about anything in this opinion that could have an adverse effect on that? Or do you care about that?
I'm a believer that courts should decide the case in front of them, and if the issue is not in front of them, it should be decided in another case. And if you
well, but I
proceed
think
correctly,
the issue here, the point here that the amicus brief makes is that they don't want us to decide the issue here and say something that is going to have unintended implications for another area of the law. And you would agree that that's not an illegitimate concern.
Oh, I certainly would agree, and I think it would be a fairly straightforward matter for this court to point out in its opinion that it's not addressing the tort immunity issue. And I think you can certainly distinguish the sovereign tax immunity and the underlying constitutional framework that's based on from the tort immunity. To me, tort immunity is more of a personal right not to be sued, or the sovereign's right not to be sued or to have to pay damages. Property tax is an in rem thing. We're always talking about the property itself. That property is, Florida says property, the value of property is the same regardless of who owns it. It's more of an in rem action. And so those two, to me, are a pretty sharp distinction between those two things. The king can do no wrong. Doesn't matter where the king is at. There's a concept of tax immunity that's dependent upon the broad principles of how government interacts with each other, and that certainly involves the boundaries, the physical boundaries of those governments. And although this court has not directly expounded on the issue, when you go to try to find analogous areas of the law, it seems fairly consistent that the courts have looked at this, have recognized that in the concept of taxes and tax immunity, the boundary of both the owning entity and the levying authority are significant. And we think the court could very much align itself with those decisions.
And counsel, so obviously if we said that there's immunity that's derived from the state, then there could be a legislative fix to that if the legislature wanted to. Do you agree with what your colleague said, that if we instead ruled that there was no immunity, that the legislature could also address that if they thought that it would be better, better in everyone's best interest if there were a different rule?
Yes, sir. I believe that this court expounds on what the common law is, and the legislature certainly can go in and enact a statute that places parameters on what that common law should be. It is arguable that in 196, 199 that is there. That statute provides. It has two scenarios. It has in subsections 1. A and B, that property owned by a governmental entity and used for governmental, municipal, or public purposes is exempt, and it uses the word exempt. And then there's subsection 2 that says property owned by government entities, and it includes the state, political subdivisions, municipalities, which is leased to non-governmental operators for uses other than governmental purposes shall be taxable. And there's a long body of case law from this court, beginning with Williams versus Jones, as to how we got there with all those provisions. It's arguable that may be there, and that kind of goes back to the Second District Court of where are we at now? What should we be focusing on when we get back to the Circuit Court? I would submit that we'd be focusing on the ultimate use of the property. But I do believe that it would be most consistent with the other decisions that we have out there that the finding would be that Pinellas County, when it acquires property outside of its county boundaries, would be considered to have acquired the property as any other private person, and there wouldn't be an exemption, but it could be an issue for another day. We don't believe, again, that this is an issue strictly confined to has there been a waiver. I don't believe that that's an appropriate analysis. I do believe we go back to this court's decisions in Alford, Park and Shop, Dickinson, and Canaveral Port Authority, which is our most recent vintage. And there the court said that this concept of immunity from taxation should be kept within narrow bounds. It should not be expanded, and it went on and said that the legislature would not have the authority to declare an entity to be immune from taxation, that immunity derives itself solely from the proper functioning of government, and immune entities, the court said, should be confined to the state, the school boards, the public system of education, and counties and state agencies. And the court said that we have to keep it narrow there, and it would be inappropriate for the legislature to go around and declaring what entities are immune. Absent any further questions, I would yield the rest of my time. Thank you, Your Honor.
Good morning. May it please the court. Excuse me. My name is Don Kroll, and I'm here on behalf of Pinellas County. Let me start with Pan Am Tobacco. In Florida, sovereign immunity is the rule, not the exception. Now, Justice Kennedy, you pointed out that there's no case on all fours in the state of Florida. We concede that. But the jurisprudence of this case, of this court and the Florida courts since Kagan in 1916 have repeatedly said that a county shares the state's immunity. It's just some piece of the state's immunity. It doesn't say within the county's boundaries. And then it went so far in Park and Shop and Dickinson to talk specifically about that sovereign immunity as applied to taxation. Now, my colleague was also talking about Canaveral Port Authority. Well, port authorities are not constitutionally recognized, as counties are, as being part of the state. That was the distinction there. But Canaveral went into the great detail about the history of that state's sovereign immunity and how it has applied. Justice Groshans, you asked about Florida versus Georgia distinction. These cases outside of the state of Florida that are dealing with state versus state principles of federalism, where the states granted power to the federal government, not the other way around, and these cases involving foreign nations, Indian tribes, that deal with treaties and federal statutory schema that are not at play in the state of Florida, are simply not in any way analogous to be able to draw principles about what the long-standing internal Florida jurisprudence is. We believe that to the extent that the hypotheticals that were presented at the Second District Court of Appeals that appeared to sway them are best suited for legislative action. Public policy is a place for the legislature to hear from all of the facets of the citizenry, not just those that are appearing in a court case and having decided their case or controversy before the court, but going through legislative session and committees and hearing all the different pieces and understanding the thread that may be pulled on the sweater as downstream effect on unintended consequences for other types of sovereign immunity. We believe 768-28, again, supporting the concept, doesn't define geographic boundaries. Now, clearly it's bounded by the state's boundaries, but it does not further subdivide that protection. Now, Park and Shop is another good example about why we believe that the state's immunity is imbued in the counties. That case didn't involve the state. Again, that was about a county who leased property. But the court went on to look back at sovereign immunity and how counties are cloaked with the state's immunity over many decades at that point even, to say that the county property could not be taxed, not only by the county, but also by the city. And they talked about some policy considerations that my colleague points out in his brief about that are lost when you leave, Pinellas goes into Pasco County. But there are other taxing authorities in play for which those policies or considerations are irrelevant as well. In fact, in the Park and Shop case, they said the city can't tax the county either. Well, those considerations about the government not taxing itself and the state not taxing itself, the state wasn't a party, wasn't a consideration. Those simply aren't at issue as they continue on. And then Dickinson recognizes again that the county shares the state's sovereign immunity from taxation. As to the zoning laws question that was asked, the distinction between jurisdiction and geography, we believe, is important. You heard our colleague talk a little bit about if a county buys property outside the state, it should be, in his words, the policy that we are participating as a private actor. Well, the legislature has entitled counties to exercise the sovereign power of eminent domain beyond their geographic boundaries. Now, it would be an absurd result to say the county could buy property, take it, force a sale of property, and then not have immunity for taxation or tort there. That would be absurd. And certainly, all of these things are swirling around at the same time since Kagan in 1916. The legislature waived sovereign immunity.
Or did Pinellas County take this by eminent domain?
Excuse me?
Are you suggesting that Pinellas County took this property by eminent domain?
I am not, sir. No, sir.
Could a county take property outside its geographical borders by eminent domain?
Yes, sir. There's a statute on point that says so. It's 127.01, I believe. But for some minor exceptions, I believe for recreational purposes, yes, the counties are. And Prosser versus Polk is a case.
But what the statute says is that they can't do it for certain purposes.
Well,
and so by implication, it's been interpreted that they can do it for other purposes.
I believe the text specifically grants to counties the state's power of eminent domain and then limits it the way you have described it.
Well, maybe the Prosser case didn't explain that correctly.
I may be incorrect, but that is my understanding and my belief, sir. Most importantly, we believe that this case comes down to the extent that there is an open question on where sovereign immunity applies beyond a county's borders within the state of Florida, that the policy considerations that are wrapped around that clearly need to be addressed only by the legislature, that it is best suited for the legislature and sovereign immunity as a separation of powers issue, that should be addressed at the state legislative level and allowed to the extent there are problems that need to be addressed, be addressed. There was, by the way, we're talking about large pieces of property being owned by a sovereign in the boundaries of another sovereign. That happens all the time. The federal government, the state authorities own property. Within Pinellas County, there's a huge veterans hospital on the water. The fact that the county, Pinellas County, or if this court rules that we don't have immunity from taxation, that doesn't fix the policy considerations for Pasco County that are argued by my colleague. Because again, there is not only one sovereign in any one place, there are often several. So the Second District Court of Appeals in the majority simply, we believe, was swayed by the policy questions that were brought forward by them. Justice Black's dissent was point on. His analysis is correct. and it gets you consistent with all of the jurisprudence to this point. With that, unless there are further questions, I will yield the rest of my time.
Thank you. And we appreciate the professionalism and competence of the counsel on both sides, and we're adjourned.
All rise.